Hello, everyone. We have noticed an interesting phenomena with some of our clients recently. They are getting letters from USCIS saying that USCIS has closed their case. This is not a denial, but it can cause a delay in your case and impact your legal status. So I wanted to talk about that today. My name is Raluca Hanea. I provide immigration, estate planning, and family law services in Lawrenceville, Georgia. My marketing and office manager, Nina Clear, is here with me. Thank you for all your likes, comments, and shares as they help others to see our videos.
Okay, so tell us again why you wanted to talk about this subject.
Well, we have found that, unfortunately, it seems like USCIS is engaging in things that might be considered delaying tactics. This new strategy appears like it might be just another one of these.
And by delaying tactics, you mean to slow down the application process?
Yes, it might be a way to make their numbers look better. If they're able to close cases, in some instances inappropriately, they no longer have that case counted against them. What everyone in immigration know is that this is not a fast process and seems to be getting slower almost every day.
Okay, and so you see this administrative closure, in quotes, administrative closure by USCIS as a way to, one, continue to comply with this administration's goal of reducing immigration, right? Reducing approvals. And two, make it look like USCIS is processing applications more quickly so their numbers look better because these aren't even counting anymore.
Yes,
right?
That's right.
Mm-hmm. So will you explain a little bit more about what an administrative closure is when it's done by USCIS?
Yes, I do want to point out that there is also an administrative closure of a case that is done in immigration court by an immigration judge. But this should not be confused or thought to be the same thing as what USCIS has done and what we are talking about in this video today. Also, since we don't want to give away private information about our clients, this is going to be an aggregate of information from several cases. The first thing to know is that our clients who received an administrative closure first received a notice to appear, also known as an NTA.
Can you explain a little bit more about an NTA?
Yes, an NTA, again, this is short for notice to appear, says that you must appear in immigration court for a hearing. The letter will usually have a time, date, and a place listed. The notice will also give you more information about what is happening and why you must appear. Most often it is because removal proceedings have been started against you.
And is it required, like are you legally obligated to go to a hearing that is in your NTA?
Yes, but the notice must meet certain requirements in order to be valid.
Can you tell us what they are?
Sure, I think it might be good to do a live about that in another time because I really want to concentrate on what an administrative closure by USCIS is in this video. But
okay.
We'll explain that in another video.
So can you request a change? I know you said in the NTA it gives you like a time and date. Can you request a change of that time and date if you're not available?
Not usually. Sometimes the NTA doesn't even list a time and a date. And if it doesn't, once a hearing is scheduled, you will receive a notice of hearing at a later time. But to be clear, if you do not go to your scheduled hearing because of a new Department of Justice policy that the judges must follow, you will have an order of deportation entered against you. And that is something you don't want to have that happen.
Okay, and I think I've seen in the news, like I remember seeing stories about how USCIS was issuing NTAs with like random dates and times, like Saturdays and Sundays or 2 in the morning, and people were showing up because they were freaked out, right?
My My computer started.
But there wasn't a hearing going on, right?
That's true. And unfortunately, that has been happening. I have found that even when our clients go to the court on the time and date that was scheduled, the hearing hasn't been put on the judge's calendar, so they must wait for another hearing and for another date and time.
That sounds super frustrating.
It is frustrating because you want to know when you go to court you're going to have the hearing or not. Our office makes every effort to verify that the hearing has been scheduled, but we don't have very much success, and I will always have my client appear. Even if we weren't able to verify if the hearing, it's still at the same time and date. So we just want to make sure that they don't miss it and have a deportation order entered against them in absentia.
Okay, and that means that they're absent, and so they just issue that, right?
Yes.
Okay. So what happens with this USCIS administrative closure?
So if you are in removal proceedings, meaning that your case has been transferred to EOIR, which stands for Executive Office for Immigration Review, then USCIS will close any application you have sent in to them.
So then what you're saying is USCIS will not make a decision on your case?
No. If EOIR now has jurisdiction over your case, then USCIS cannot make a decision, and it must be decided now by an immigration judge.
Which sounds kind of bad, because especially here in Atlanta, we know that the immigration judges, like their approval rating is not approval of people saying they're good,
yes,
but them giving immigration benefits to someone is very low, right?
That's true.
And so it kind of seems like you might have a really poor chance of getting a positive decision.
That's true. Although statistics have shown that those who hire an attorney, even in this situation, are more likely to get a positive answer than those who don't.
Okay, so if someone has an NTA, it sounds like you recommend that they take an attorney with them to the hearing.
Oh, yes, absolutely.
Okay, and is there anything else you can do to get your case back to USCIS once they have closed it administratively?
Yes and no, and this depends a lot about the facts on each case. You should consult with an attorney about this because it's very dependent on your case's individual facts. So recently, I was able to request USCIS reopen a case because the law hadn't been followed in closing it. But this isn't something, hopefully, that we will see frequently. So it's very important to ask an immigration attorney to review the facts of your case and ensure that the government followed all of the rules that they needed to make the transfer legal.
So if they didn't follow all the rules, you might be able to do something.
You may. The government might try to fix the mistakes they made but having an attorney means having a legal scholar who can hopefully effectively argue why it would be against public policy, for example, to allow the government to fix it. And you might be able to get USCIS to reopen your case.
And what happens to someone's status, like their legal status? So they, if their case is closed by USCIS and they're placed in removal proceedings?
They don't have a legal status.
And it seems like the obvious answer, but could that cause a problem for them?
It could. It is always a problem if a person is here in the United States without a legal status. It could impact their ability to work because they may not be able to obtain employment authorization, and it could make it so they can't get a driver's license depending on their state rules.
Okay, and so is there anything that someone can do to protect themselves?
It really would be best to talk to an attorney about that. If you have received a notice to appear, you can always also check your case status by calling a number. It's a 1-800 number, and enter your A number or alien number. The number you can call to verify that is 1-800 898-7180. I recommend that you ensure that BIA, which stands for Board of Immigration Appeals, and EOIR always have your current address. With USCIS, you must notify them about any change of address within 10 days. But with BIA or EOIR, you must notify them within 5 days of any change. Most importantly, make sure you keep in touch with your attorney or hire one if you didn't hire one already. I want to mention something else briefly. I mentioned that sometimes cases have been closed administratively in immigration court. This is done through prosecutorial discretion. In short, the PD. The prosecutor or the Department of Justice attorney asks the judge to close the case, usually to allow the immigrant to pursue some type of benefit or a decision on an already submitted application, such as TPS or DACA, or getting their green card through marriage. And this helped the judges too, because when a judge issued an administrative closure, it would move the case off the immigration judge's very full calendar. However, and this is the really important part, in 2018, the Department of Justice issued a new policy saying that the immigration judge now cannot administratively close a case except in very limited circumstances. So because of this, do not expect that you or your attorney can now request this to happen in immigration court.
Okay, so what I'm hearing you say for the most part is if you have an NTA, a notice to appear, you should hire an attorney so that they can review how your case was handled and determine if it was all legally done.
Yes, many times people think they can rely on what happened to someone that they know to determine what will happen in their case. But because the policies and procedures are being changed so frequently, it is really important to hire an attorney who can review the facts of your individual case and determine if all parts of the law were followed on your behalf. And if they were not, they can make the best legal argument for your benefit. Thank you so much for everyone who was watching. Please call our office to schedule a consultation because we are always here to help. Thank you. See you soon.